Hi, this is Attorney Mike Gravel coming to you from Chicago as usual, and today's going to be a little different. We're taking on a serious case. It's the Kyle Rittenhouse case. He's charged with 2 counts of homicide, and it's a self-defense case. It's absolutely fascinating. It's going to end up going to trial here starting in November, I believe, and I even give a little prediction as to what I think given the current information that I have. Let's do it. Okay, this video involves the analysis of a criminal defense attorney who specializes in use of force, and he's sort of covering this case, and for good reason. It's a very high profile case involving his area of practice, and he seems to really know what's going on with those things. But it brings up some fascinating issues that I deal with, and what they're doing is effectively motions in limine, and they're trying to figure out which evidence they're going to allow in and not allow in, and the big test there is that evidence more probative than prejudicial, and that's where all the fights are. So he starts out with a little discussion of that, and then goes into some of the things the prosecution's trying to get in, and I think it's very telling about the case and its current status.
No practical use to the jury. If it's modestly relevant but highly prejudicial, it wouldn't be admissible because of that imbalance. If it's slightly prejudicial but still highly relevant, well, then it still might be admissible evidence. So often before the trial starts, you don't want these issues about whether the evidence is going to be admissible or not to be argued while the trial is taking place. First of all, the jury's not allowed to hear these arguments. Obviously, it could be decided that a particular piece of evidence is inadmissible. You can't have that argument in front of the jury, or they've already been made aware of the evidence. So you have to have this argument outside the hearing of the jury. You prefer to do that before the jury's even been selected, so that when the trial actually starts and the jury's in the booth, you don't have to constantly have them exit the courtroom, so you can have these discussions outside of their hearing. And that's what we're doing in this case. What we did last Friday for roughly 3 hours is argue in front of the judge, but before a jury in this case even exists, about what particular aspects of evidence will be admissible. Now, generally speaking, most of the evidence in the case is not really being contested, so it's mostly admissible, but there's often pieces of evidence kind of on the margins that one or the other party would like to present to the jury, but the other party has an objection. And that's partly why we have an adversarial legal process, folks. So you have one side, I'd like to get evidence, piece of evidence number 1 in front of the jury. The other side objects. They argue it out in front of the judge, and the judge makes the final decision. And by the way, that decision is almost entirely really final. The appeals courts give very broad discretion to trial judges to make these calls on evidence. And there's a number of reasons for this, but the most practical is that the appellate courts don't want to do the job of the trial judge. Initial matters of evaluating evidence fall within the scope of the trial court, and the appellate courts are loath to assume that burden themselves, which means that when a trial court judge makes the decision on whether a piece of evidence would be admissible or not, unless that decision is really egregious, what the appellate courts would call an abuse of discretion, that decision's effectively final.
So I think this is interesting, and we deal with the same things in the civil context. And I was a prosecutor a long time ago for a very brief period of time, but I never did anything like this. I'm not going to claim I did. But he does a nice job of setting this out. And what you're doing is you're looking at all the evidence that's coming up. It looks like they're going to start picking a jury on this case on November 1st, and this is a high-profile case, and it's very heated, and it's politically charged and everything else. So they're doing all these motions ahead of time. Well, you do motions ahead of time in all these cases. You try to argue what you can and can't get in. It's one of the most frustrating things when you try a jury case. They don't realize that there are arguments you can't make, and there's pieces of evidence that are excluded. And if the judge says, for instance, you can't bring up this topic, and you do, that's grounds for a mistrial and sanctions against the attorney.
Because of how high the standard is for that to happen. So whatever decision you get out of the trial judge is probably the decision you're stuck with for the entirety of your trial. Your lawyers better be making their best arguments right there. In this particular case, a lot of the evidence around the Kyle Rittenhouse case, and of course, essentially what he did was he shot and killed 2 men and rather grievously injured a 3rd man. And that's led to charges, 2 counts of murder, a charge, some form of aggravated battery for the injured man, and then a variety of other charges the prosecution's ginned up in this case. And to all these charges, effectively, except there is a gun charge still in play here. I'm not sure it'll end up in the trial. The judge here, Schroeder, hasn't yet made a decision on that. But all the use of force charges, the murder charges, the charge for the injury to the 3rd, quote-unquote, victim in this case, the legal defense being raised to all of them is self-defense. And in fact, Rittenhouse was indisputably being pursued and arguably attacked by each of the 3 men he shot. So he's got on its face a very viable self-defense, legal defense for all 3 of those shootings, each in succession.
That's very interesting. I remember this stuff when it was happening. I remember seeing video clips at the time. I have not followed it closely. This came across my feed, and I thought that this was a fascinating preview into this trial, and that's why we're looking at it.
And we actually see this as we go through this evidentiary hearing. The specific pieces of evidence that are being proposed and either approved or rejected by the judge are kind of on the margins of the case. But you can tell where a party thinks it's strong or weak based on the nature of the evidence it's fighting for. If they're fighting hard for weak bits of evidence, that suggests that they don't have a strong core of direct evidence in their favor. And I think we see that here in the prosecution's arguments for the evidence they're trying to get admitted today. So most of the evidence here is not in dispute. Rittenhouse definitely shot these people. He's not disputing that. That's inherent in the nature of a self-defense case. He's not saying it wasn't me, I have an alibi, I was someplace else. He's saying it was me. I shot them intentionally, but I did so with the legal justification of self-defense. So the use of force itself is inherently conceded by the defense in this case. The only really questions in dispute are those elements of the claim of self-defense, and hopefully by now all of you know the 5 core elements in the claim of self-defense are innocence, imminence, proportionality, avoidance, and reasonableness. We won't dive into those today for purposes of remaining within the hour of the show. Instead, we'll focus on the types of evidence that the prosecution and the defense argued to be brought in today. So the first piece of evidence the prosecution tried to bring in, get admitted into evidence, approved by trial judge Schroeder, is what's known as other acts evidence. So it involves an act that's separate from the core events that underlie the criminal charge. But the prosecution is arguing that these other acts will inform the jury in some way, provide some context, be evidence of some kind of motive or intent or a modus operandi, a very definite, specific type of pattern of behavior, and that's why the prosecution wants them admitted.
This is interesting, and that's why I chose this bit. This is exactly what the problem is that he was setting up with. Is a piece of evidence more probative than prejudicial? That's the standard they're always going by. This sort of evidence that the prosecution is trying to get in is just not. The judge sort of sees it that way. Sort of not a good sign for the prosecution that this is what they're fighting about. However, having said that, when you're going to trial, sometimes you ask for a lot more things than you expect to get. And that's not a bad strategy in and of itself. So you sort of ask for too much and let the judge rule against you on some things. That's very typical in this motion to eliminate kind of context.
What such other acts evidence is not admissible for is to argue that a defendant has a propensity towards some bad conduct. So if someone's charged with assault, for example, or battery, they're to be judged on the facts of this particular case. The fact that they might have engaged in assault or battery in previous instances in their life, and to argue that, hey, they've gotten into fights before, that means they got into this fight unlawfully this time, they have a propensity for violence. That's not normally admissible as evidence. Propensity evidence is specifically prohibited by the rules of evidence. So
And it's interesting. That's exactly why the prosecution wants it in. I'm not accusing them of anything. This is what attorneys do. You're not supposed to have it. So what you do is you try to characterize it under some other exception to get the judge to get it in. But why do they want it in? For propensity. They want they want to prejudice the defendant. They want the jury to think he's a bad guy. That's it. They'll give another excuse that is allowed. And this is our job. And there's nothing wrong with that. All attorneys do this. And that's why we have an adversarial system. And that's why he has an attorney calling it out and saying, no. This is propensity evidence.
Other acts evidence has to be proposed for some other purpose. Now, it could go to motive or intent. As I said, there's a variety of factors that may make it admissible. But mostly for those to be the basis for getting these other acts evidence admitted, it has to be tied pretty closely to the actual facts of the underlying case, involve the same people or the same property or the same tools or the same weapons or the same beliefs or circumstances, something tied very closely to the facts of the case. And that was mostly missing here. So the first other acts evidence that the prosecution argued for in this hearing involved a purported assault. That's how the prosecution characterized it. An assault by Kyle Rittenhouse on a female, a woman, some months before the shooting in Kenosha. And the circumstances of that use of force, that was a June 1st event of that same year, 2020. The surrounding circumstances were that Kyle's sister and another girl got into a physical confrontation. They were basically in a teenage fistfight. And Kyle intervened in that fistfight on behalf of his sister. So the prosecution would like to get this admitted, they say, because it shows that Kyle tends to insert himself into fights that are none of his business, as the prosecution characterizes this. The prosecution says, hey, this is really a case of mutual combat. Two teenagers wanted to get into a fight with each other. And Kyle decided to unnecessarily insert himself into that fight. Now, if that already doesn't sound very credible to you, because, I mean, an alternative reading of this is that Kyle came to the defense of his sister, and what good brother wouldn't do that? Well, I'm right there with you. But in any case, the real difficulty is that even if what Kyle did was wrong in coming to the defense of his sister, which I think is an uphill fight already, the circumstances of this fist fight with the sister and Kyle intervening and striking the other girl who was fighting with his sister is so far removed from the facts of the Kenosha case that it doesn't seem to really have any relevance to it at all. Remember, the Kenosha case involved deadly force, chaos, riots, Kyle Rittenhouse purportedly carrying around a fire extinguisher to put out fires, being chased by each of the men and attacked by each of the men he ends up shooting. A completely different set of circumstances than a teenage fistfight on a pier someplace months prior to the Kenosha events. And the judge took that view as well. Of course, that was all the defense argument. It's simply too far removed in circumstances, in time, to be of any use to the jury in this trial in arriving at a conclusion on whether or not Kyle's conduct that night in Kenosha, his firing of those shots, his shooting and killing of two men and shooting and injuring of another, whether or not that was lawful self-defense. The teenage sister fistfight scenario really sheds no light on the Kenosha shooting event at all. And that was the decision of Judge Schroeder in this case.
I found this fascinating. A little background, because I watched more of this video. This video is an hour long, and I'll put a link to it in the description below so you can do that. I think he's going to cover the whole trial. He's a real sharp guy. He does use of force cases, very specific. He knows what he's talking about from what I can see, but you are definitely getting a defense perspective in this case. But I also think that he really knows what he's talking about. And when he gives this example, that is not even close in my mind. I'm surprised the prosecution is even arguing for that. It's probably not the core of the case. It probably doesn't, the sort of propensity evidence isn't going to carry the day here, I don't think. But the fact that they're even trying it is I believe, a bad sign for the prosecutor. And I said, sometimes you ask for more than you expect, and that's true. But there's also a limit. You don't want to ruin your credibility with the judge. If you start asking for things that are just clearly wrong, what happens during the course of a trial is the judge starts to lose faith in you, and they just start to think that all your requests are unreasonable, and it's not a good scenario.
So he's not going to admit into evidence I believe it was cell phone video of that Kyle's sister teenage fistfight event some months earlier.
Well, there you have it. This Kyle Rittenhouse case is going to be a big deal here coming up. They're going to start picking a jury in November, I think, and it's going to start being all over the place. This came across my feed, and I was watching it just out of my own interest. It's not what I usually do. It's more serious, but I do think it's a very interesting case. I teased it with this. I'll give you my thoughts on it. First of all, I have not seen all the evidence or anything close to it. No one can say that until the trial's occurred. So you're going to have to see what goes on at trial. But, I'm entitled to an opinion nonetheless. And from what I've seen from the video clips, and I've not followed this closely, let me just say that right now. So based on that, and I watched more of this video, and from the information I know, I think the prosecution is going to have a really hard time getting a conviction on the murder charges in this case. If you look at the video, it really looks like he's being attacked, and self-defense makes sense here. That's just my opinion from the few facts I know so far. That opinion may change if I were to watch this trial, which I doubt I will, because I think it's going to be pretty long. I've got a lot of stuff going on in November, so I'm probably not going to be watching it day in and day out. But I do think that this was a really interesting preview. This guy says in his video that he's going to be covering it. So if you're interested, you might want to check out his site. And I think he's going to be covering the whole trial starting with voir dire.